Please be seated. Back on the record in case number 19 CR 586 A and B. Cases styled State of Ohio versus Daniel Groves and State of Ohio versus Jessica Groves. Counsel and the parties and the jurors are back in the courtroom. Before the recess, the defendants, both defendants, Daniel Groves and Jessica Groves, have rested their case. Does the State of Ohio have any rebuttal evidence?
No, Your Honor.
State has no rebuttal evidence. Ladies and gentlemen of the jury, we've come to the conclusion of the evidence in this case. The lawyers and I, starting a couple weeks ago, but during the evenings and the recesses over the last several days, there's been a considerable amount of time going over jury instructions. We are going to work over, it's going to take a little more time for us to finalize those before they're ready to be given to you. We are going to break for our lunch break at this time. It's early. And I'm going to give you a little longer for lunch because these are pretty well complete. There's a good bit we still have to go over. So I'm going to have you be back in the jury room at 12:30. Gives you about an hour and 25 minutes, maybe an hour and 20 minutes. Hopefully we'll be done by then. If not, you may have a little break there. The bailiffs are going to go restock the refrigerator while you're at your lunch break. And the lawyers and I will be working through the lunch hour. At this time, I'm going to excuse you for your lunch break. Do not discuss this case amongst yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Once again, it is your duty not to form or express an opinion on this case until it's finally submitted to you. When you come back into the courtroom, we'll begin closing arguments. Thank you. Bailiff will excuse you from the jury room. Court is recessed. We're back on the record on case number 19 CR 586A, 19 CR 586B, State of Ohio versus Daniel Groves, and State of Ohio versus Jessica Groves. Counsel and the parties are present in the courtroom. The jury is on their lunch break, not present in the courtroom. Several times this week, the lawyers and I, either during recesses or evening recesses, have been talking about jury instructions. I think earlier this week, counsel, let's start with verdict forms, that might be easier. Counsel were given a copy of proposed verdict forms. For the defendant Daniel Groves, I have 22 verdict forms, 11 for guilty, 11 for not guilty. And then for the defendant Jessica Groves, I have, once again, 22 verdict forms, 11 for guilty and 11 for not guilty. Have the counsel all received copies of those?
Yes, Your Honor. Yes, Your Honor.
Yes, Your Honor.
All right. I would point out to counsel that as to count 4, the charge of child endangering, there is a special instruction if the jury would find either defendant guilty beyond a reasonable doubt. They would further consider whether, beyond a reasonable doubt, whether the violation did or did not result in serious physical harm. And then as to count 6, I believe, there would be an additional finding if the jury did find either defendant guilty of the charge of interference with custody. The jury would further go on to decide whether the defendant was guilty beyond a reasonable doubt, and if they were guilty, then whether beyond a reasonable doubt the violation did or did not result in physical harm. Any objections to the proposed verdict forms?
No, Your Honor.
Not at this time, Your Honor.
State?
No, Your Honor. Thank you.
Does either side feel that any of the verdict forms as to the other 9 counts of each defendant's indictment require any other special findings?
No, Your Honor.
Not at this time, Your Honor.
Stephen?
One moment, Your Honor. Nothing further, Your Honor. Thank you.
We did discuss earlier in the week and then again earlier today about the gross abuse of corpse count. My view of that count is, even though there is a inferior degree count and a greater degree count, that those are separate, distinct statutes and do not require jury fact-finding to enhance the penalty. Would the parties agree with me on that?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Let's go on to the proposed jury instructions. Now, I think I indicated to counsel last night after our recess that I would be adding, I didn't bring my most recent copy of these instructions out. They're still on the computer. I haven't printed them yet. But yesterday, when we used a listening aid here in the courtroom, I did include a limiting instruction for the jury's use before the listening aid was used, and I also included a limiting instruction in these instructions. The difference being, I think the instruction yesterday is present tense. The one I've included in these proposed instructions was past tense, since the jury's already considered that listening aid in the recording. Any objection to the language as we've gone over in chambers concerning the listening aid?
No, Your Honor.
No objection at this time, Your Honor.
No objection, Your Honor.
All right. There was a paragraph on page 7 of the original proposed instructions. I'd left in from a previous case, I didn't know we'd get into it in this case. I thought there was some chance, but I don't believe we've heard, other than what we heard earlier today concerning the defendant Daniel Groves, I don't think we've heard from any other witness with a criminal conviction that was introduced. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
All right. I am going to take out that what was originally in the original instructions, or the last version of the instructions at the bottom of page 7 about witnesses convicted of criminal acts. On page 8 and 9 of the last version of instructions, I have included a limiting instruction on the jury's use of the defendant Daniel Groves' prior theft conviction, and I have taken out the language that he has a constitutional right to testify, since he did waive that right and agreed to testify here today. Any other changes as to the defendants testifying or not testifying in this matter?
No, Your Honor.
Not at this time, Your Honor.
No, Your Honor.
We discussed last night, I think I gave you a copy of the OJI instruction. I have included the more specific venue instruction for the jury as to homicide cases, specifically that the court's jurisdiction to hear this case would be based upon the jury's finding beyond a reasonable doubt that the victim's body or a portion of the body was found within Scioto County. I don't believe there was any objection to that, was there?
No objection.
No objection.
No objection.
All right. Other than some clerical matters that I've changed from the last version, I'm sure I've missed in here some plural or possessive plural from time to time. Page 16, I don't know that as to the charge of kidnapping, child endangering, the statute on child endangering includes cases where you have endangering by a guardian. I don't know that's the evidence in this case, so I have removed that from these instructions. Any objection to taking out the word guardian in the body of the initial part of the charge and then the definition of guardian?
No, Your Honor, and I believe that's the only place it's mentioned throughout jury instructions.
Well, there's a description of guardian on the next count that has a different meaning of guardian,
Yeah,
but
the same meaning, Your Honor.
but as to this count, any objection, Ms. Scott?
No objection, Your Honor.
Mr. Teeman?
No objection, Your Honor, that the state concurs that the special meaning of the guardian in this count does not apply.
The count 5 on page 17. I have included in the to-wit section in the main body of that charge where it would indicate was likely to be instituted or as an accomplice did alter, conceal, remove a thing, to it, and I've included on the blank that was on your version, the body of Dylan Groves. The additional language that needs to be in that portion of the instruction.
No, Your Honor.
No, Your Honor.
Mr. Stephen?
No, Your Honor.
Clerical error, clerical changes, gross abuse of corpse, we've talked about. We had some discussion. I have drafted these instructions to charge the jury on the last 4 counts, 9, 10, 11, excuse me, not 8, 9, 10, and 11. And I have drafted these instructions to charge the jury at one time as to all 4 counts. I think I've been clear in that. Any proposed changes as to the joint instruction as to counts 8, 9, 10, and 11?
No, Your Honor.
No objection.
Tiemann?
No objection, Your Honor.
Now, the state, Mr. Tiemann, has asked for 2 instructions. We started talking about this, I believe, earlier in the week. One was an instruction as to voluntary intoxication, and 1 instruction as to consciousness of guilt. As to voluntary intoxication, I believe I've included the standard definition or standard instruction on voluntary intoxication. I believe that's consistent with the law of the state of Ohio. It's one I've used for a number of years, practicing either as the judge or practicing before this court. It would read, you have heard evidence that the defendants were intoxicated at the time of the offenses charged in the indictment. Intoxication is not an excuse for an offense and may not be considered by you in determining the existence of the mental state of the defendants. Plural, at the time of the offenses. Intoxication does not relieve a person of a duty to act. Any proposed changes to that instruction?
No, Your Honor.
No, Your Honor.
No, Your Honor, thank you.
Consciousness of guilt, Mr. Tiemann, we had some lengthy discussions about this. I believe the state is requesting that the 2 acts of the defendants which may give rise to the jury's consideration of consciousness of guilt would be that they fled from the scene. I believe that was from testimony about fleeing on a 4-wheeler from sheriff's deputies, detectives, law enforcement, and attempting to conceal the body of Dylan Groves. Anything additional the state is requesting as to the consciousness of guilt instruction?
Well, Your Honor, please the court. We did discuss the apprehension at the trailer. The state's elected not to ask for instruction as to that particular fact scenario. So nothing further.
Any objection to the proposed consciousness of guilt instruction as with those changes as drafted?
No, Your Honor.
No objection.
Mr. Tiemann?
No objection.
Otherwise, I think that concludes the proposed instructions. Any other additions, changes, deletions, or objections?
No, Your Honor.
Scott?
Nothing that I'm aware of, Your Honor.
By the state.
None on behalf of the state, Your Honor.
I will give counsel an opportunity to approach and make any additional changes, objections, once the instructions are read to the jury. Now, we've worked through most of the last hour and a half. I know the counsel was trying to get something to eat while I was sitting at my desk. Do you need a little more time before we bring the jury back down?
I'm fine, Your Honor.
Maybe if I could have a quick restroom break?
You can. I'm going to print out a final version of these and have people start copying them.
Your Honor, these are still, the verdict forms are still going to be, there are no changes to those, so.
None that I've seen. Now, if counsel believes there's changes need to be made,
So
make sure you let me know.
we can go off of these then.
Court is recessed.
Thank you, Your Honor.